to welcome everybody. Wanted to welcome everybody to the New Mexico Family Advocacy Program's 61st ECHO session. The NMFAP is a model of respondent parent representation being implemented in the 2nd, 13th, and 11th judicial districts. The program utilizes interdisciplinary teams of lawyers, social workers, and parent mentors that provide high-quality representation and the advocacy and support families in the child welfare system need for reunification or other preferred outcomes. I'm going to be the facilitator today. My name is John Duran. We also have Jen Vieira, who is going to be our IT support. Today's topic is going to be zealous representation in a collaborative practice. Couple reminders, housekeeping items, just so that we know who's with us today. You have to enter your name and email address in the chat. And then if you could please fill out the post-session survey, which is an important part of our program's data collection efforts under the federal grant. The survey will only take a few minutes. Jen will post a link to the survey in the chat, so keep an eye out for that. And we thank you in advance for that feedback. There are 1.2 general continuing legal education credits that will be offered to participating attorneys by way of our sponsor, the Corinne Wolf Center for Child and Family Justice. So we thank them for that. The form is located on the program's website in the resource library and will also be added to the chat as well. There's going to be 1.25 continuing education units that will be offered to participating social workers. In order to receive that, please email echonmfap@gmail.com by the end of the day on Friday, May 19th, indicating that you intend to receive the CEUs. Of course, that email address will also be provided in the chat. We have several presenters today. Our first presenter is Cynthia Tessman. She's a statewide trainer for CYFD Children's Court Attorneys. We have Cantrell Mosley, who is the CYFD Sandoval County Office Manager. Pavelski, who is a certified peer support worker and NMFAP parent mentor. Leslie Jones, who is currently the NMFAP lead attorney. And John Sánchez, who's a licensed clinical social worker and NMFAP social worker as well. By the end of today's session, participants should be able to determine the difference between a zealous and adversarial advocate and give examples of each. Describe why effective communication with clients, department workers, other counsel, and the court is essential for zealous advocacy. And explain why cultivating relationships, not reacting to one's own triggers, and engaging in self-care is an important part of being a zealous advocate. So at this time, I'll keep track of the time, but if I'll pass this over to, I believe, Cynthia Tessman. Any questions? Just go ahead and put them in the chat and we'll respond to them as we see them.
Thank you. I think we are actually handing it to Leslie, who is going to be sharing her screen for the presentation.
Thanks. Yes, so welcome. I want to encourage people to, if you can, please turn on your cameras. I know it's lunchtime and you might be eating, but it's helpful if you can do that. I will also, I'm going to give a little disclaimer, which is that this was Kristen Conley's presentation. She was not able to be here, and so I have stepped in for her. So one of the first things about this is that for attorneys in particular, you know, we're bound. We have a code of ethics that we're bound to provide zealous representation for our clients, and our contracts in these cases also require that we provide zealous representation. But we're also in a system that we know requires collaboration in order to achieve the best outcomes. And so sometimes it can be a tricky balance for us to decide how much to push or not, how much to cultivate relationships and in what ways, and learning how to kind of finesse all of those things so that we can achieve the best outcomes for our clients while meeting our ethical and contractual obligations for zealous representation. so kind of starting out in these cases, you know, and as when we come into the cases, we've got maybe pre-filing meetings or initial assessment planning conferences, now IPMs, there might be mediations. And we want to remember that those are not the times to come in with guns roaring and pushing for discovery and you know, trying to argue our case. This is the time that it's really important that we actually start to develop those relationships that are going to help us throughout the case, but also are going to help our clients, because part of what we need to do as zealous advocates is to model how we can advocate strongly, but without being adversarial, without being accusatory, and being able to develop those relationships. So we can model successful relationships, how we can have successful relationships in this context. One of the things that happens with that is, and how we get there, has to do with how we see the other people in our practice. And I don't know why this slide is not coming up. The whole slide's not coming up. Oh, I see, because it's coming up. So these are some things that we think of as how we view both our clients and the people that we work with that we may think of as being on the other side or on our side. And so I'm going to share a poll, and it will tell you where to go. Your answers will be anonymous, so we won't know your answers. But if you can, please go to the website there and enter that code, and then you'll be able to answer those questions. And it's on a sliding scale of strongly disagree to strongly agree. And you answer those questions, and then they will show up for us as you answer. So it'll take a couple minutes. Okay, thank you, Shasta. Looks like we have 9 responses so far. So be great if we can hear from a few more of you. We've got 23 people on, so. So James, if you see up at the very top where it says go to www.menti.com. So yeah, so go to that website, and then it will open up and ask you to enter a code. So you'll have to open a new window on your desktop.
Okay.
Or you can do it on your phone too, if that's easier. Give like another minute because we're gonna need to move on. But. So if you just, if you're finishing up, please go ahead and do that. But if you can kind of see, it's really pretty interesting to look at these answers. But what we want is for you to think about what that says about how you see your clients and the others you're working with in the system, and how maybe they perceive you as well, in terms of how kind of well you listen, how open you are, and what kind of an advocate you see yourself being within the system, and kind of what you expect from the others in the system. Okay, so I'm going to go back to our PowerPoint. Okay. And Cantrell and Cynthia, you want to talk about this one?
Sure. So one of the things that is different from criminal cases is that we do have timelines that have to be honored, whatever's happening in the case. So in our cases, delays can actually hurt the child and the family. So one of the things that we like to encourage is getting that collaboration right from the very beginning so that we can get the cases moving and hopefully reunify the families well before any of the timelines run. Under the Adoption and Safe Families Act, which is codified in New Mexico law, it is mandated that the department seek TPR when a child's been in foster care for 15 of the previous 22 months. So we have to do that. That's just required. And those timeframes were put in there because we don't want children to languish in foster care. That's not healthy for the family or the child either. So it really is to try to push us to get things going right at the very beginning, get the collaboration going so that we can reunify families quicker. Go ahead, Cantrell.
What really helps us when collaborating with these things is when workers send out, hey, we would like to set up an IPM, we would like to set up the pre-adjudicatory conference or the pre-perm conference, if we have good ideas of what times and stuff, because that keeps us on a really good schedule.
And one of the problems if we don't meet these deadlines is that our 4E funding is affected. And we are not the wealthiest state, so we do rely on a lot of federal funding to be able to support the programs that we have in place. So whenever we lose 4E funding because we didn't get the right finding at the first permanency hearing, or we didn't file when we were supposed to file for TPR, things like that, then the state loses out on money to be able to provide more programs and services to help families and children. That 4E funding also goes to help provide things like permanent guardianship subsidies. So to be able to help families whenever they're doing a permanent guardianship to be able to have the same types of subsidies that we have in adoption cases as well. So it is a huge disadvantage to us if we do not follow the timeline requirements, just as a state in general for not getting that funding.
And I just want to say, as a counsel for parents, respondents, or guardians, I think this is like a classic example of trying to balance that. You know, you may have a client, especially if your client has got some criminal history, and they've had the experience where delaying and delaying and delaying has resulted in the case getting dismissed because now the officer is long gone, and you know they end up without that's not going to work well for them in this case. And so being a zealous advocate in this case may mean really counseling your client that in the end it could end up working to their disadvantage because of that mandated timeline, but also because it could mean that if the case goes south, their relative who could take guardianship of the kids, maybe there's no longer 4E money for that if timelines haven't been followed, and that could really impact them as well.
I do want to say that I think the most important piece of all of those timelines is just that the money is important, but I think the most important piece is being able to return the child home quicker. And the less we delay, the faster the kids are going to go home. And that's what's best for the children and the families. So if we follow what's best for the families, then we're going to be able to meet all of the rest of it and get the financial piece of it as well. And Shasta?
Thanks. Do y'all have advice for, particularly in the guardian ad litem role, how we can work with the department or encourage the department when they are missing those TPR deadlines? And even if we take the next step to file the TPRs, we receive resistance from the department when plans have been changed to adoption already?
So I'm going to say, I really think that good communication between the worker and our respondents council and our GALs. I've had that happen one time. Sherry did that to me one time and I learned a valuable lesson. And I know, you know, and that doesn't happen again once it happens once. I think that we learn best from our respondents council and our GALs pushing us to do things. I do think that having more conversations, I think what worked really good in Sandoval County was to have a better relationship with our respondents council and our GALs. You know, we had some brown bags in the very beginning. We've had the same people and continue to have those ongoing conversations. And so when a timeline is coming up, you know, whether it be Leslie or Sherry saying, Cantrell, you really need to get this hearing done, and me pushing whatever CCA is there, that's really helpful. But it is that communication, I think, pushing and telling us and talking us through it.
I also see there is a question in the chat. Do the exceptions listed in the TPR statute affect the Title IV-E funding? If we can find a compelling reason for not filing a motion for termination of parental rights, then that affects how things are viewed under 4E. So yes, we have to be able to find one of those if we're not filing the motion for termination of parental rights.
Thank you, Cantrell. That was super helpful. I am wondering about communication directly with CCAs and if there's any ideas on how we can do a better job on that when TPRs just are not getting filed by the department.
And I think it's going to depend on, is it because it just the CCA doesn't have time because of all of the other demands in the case, or is it that there's a disagreement in filing a motion for termination of parental rights versus?
I think it's the time and then uncooperation with the GAL after the TPR is filed by the GAL.
Okay, well, if you're not getting cooperation from the CCA and you prosecute the termination of parental rights motion, then you get attorney's fees awarded to you. So, I mean, I think one of the things you can do is contact the CCA. If that's not working, I would bring their managing attorney in to make sure that it's very clear that that's becoming a problem and that you will be proceeding to go ahead and do the motion yourself and be seeking attorney's fees. And then if the managing attorney can't help allocate additional resources, then maybe that's something the department has to consider, is being willing to pay out the attorney's fees for the assistance.
Hey, I'm going to move on to this next slide. And John, I think you're up on this one first, and Catherine.
All right. Good afternoon, everyone. So in regards to these meetings, the pre-adjudications, permanency, IPMs, and mediation, one thing that's really important for us on our family advocacy team is that initial contact. We try to make that as soon as possible once the case is assigned to us so that we could start to build that rapport with them. We need to try and identify as many client strengths and needs as possible because, as has already been put out, everybody has their own job to do. CYFD has their goals they need to make, the lawyer has their needs, and we have ours, is trying to be the best advocate for our clients as we can. Some of the ways that we do this is we do sit with them in court. We go on home visits. We make calls. There's frequent texts between clients and us. And many times when it comes to collaboration, the defense team will be on those text strings so that everybody's kind of in the same on the same sheet of music, knowing exactly what's coming on there. And we also have, we meet with our defense team as often as possible, especially when the client feels that they have a question prior to court, maybe prior to mediation or any of these IPMs, so that way we can go in and we know that we're advocating as best as we can. We want our clients to feel like they have a say and that they're heard. And I think it's just very important that we build that rapport as early as possible so that we can get them to understand that we're there for them. Catherine, anything else to add?
No, we just work with the parents like right away as soon as possible so we can try to help identify needs that they may feel they have, because they may be more willing to share with us that they need help with a food box, or that they're having problems with domestic violence or things like that, where they may be less likely to share that stuff initially with the PPW or with the department because they feel like it's going to be used against them, or that it's just a negative. They don't realize right away that the department is there to help. And so that's part of mine and John's job, to work not only with their attorney, but to try to get them to work with the GAL and to work with the department and to realize they are there to help.
I think this also happens a lot in these meetings. So these pre-adjudicatories and these pre-permanency meetings, the department is moving towards the IPM process. And I think it's important for our FAP workers and our parent advocates that they're helping parents understand that the facilitators are now going to be the workers that they're working with on a daily basis. And so those people are going to be facilitating a lot of those meetings now. We no longer have family-centered meetings where we have a third-party facilitator. That only really happens in an investigations case. I also want to say one of the things that I wish I could advocate for is Respondents Council and GALs coming to initial assessment planning conferences and getting to know families right then and meeting them before custody hearings and being involved in that initial custody hearing discussion about the plan and the assessment plan. And then at all these meetings talking about the plans, I feel like it really helps us as a team if we can talk about these plans at all of these meetings, rather than trying to fight and argue in court. When we're talking about it in a meeting together and we're coming up with a decision, that's really helpful.
Thanks. I'm going to ask Catherine to follow up on something, and then Cassandra, then we'll get to you. Catherine, I just wanted you to hit briefly on something that you've brought up a couple of times, which is sort of the flip side. Like, we want to be collaborative, but to be a zealous advocate, how does that look like from the client's perspective if they walk in and we're all being buddy-buddy? So kind of that, can you talk about that balance?
So we meet with the parents and we talk to them about, I mean, all of you guys work together, right? All of the attorneys work together, all the GALs work together, all the PPWs. But when you're the parent and it's your case and you're going into this meeting and maybe you show up last minute and everyone's talking and everyone's having a good time and they're just all getting along. We have already explained to them, like, these people work together on the daily. they have to have a working relationship. They have to have a professional relationship. But being that they have that, your attorney is going to be able to better advocate for you because they have these good relationships with the PPWs or with the CCAs, with whoever that is. We are able to just be there with them and let them know that they have somebody, because sometimes when you go into those meetings, the parent is there by themselves. They showed up there by themselves. They didn't have someone to go with them. And then in the beginning, when it's just you and your attorney, you don't always know that you can trust your attorney, right? So being able to be with them from the beginning and let them know this is what this is going to look like, but this is how these people are going to help you. You just have to be willing to express that you need the help and then be willing to take it.
Thanks.
Can I just intervene
yes,
really quick?
go ahead, Cynthia.
Sorry. I just wanted to follow up on that. I really appreciate that that's addressed with the parent beforehand, but as the attorneys, we still need to be cognizant of how that looks. We still need to take a step back when the parents are there and recognize that they are there by themselves, that they probably are going through an extremely traumatic time in their life, that they don't have a good relationship yet at the very beginning with their attorney because they just met them, and that we need to be able to help facilitate that by not being the buddy asking how your kids are doing when the parents are walking in, or what did you do this weekend, or, you know, oh, hey, I saw you at this, but trying to have that more professional relationship so that the parent can have that chance to develop a relationship with their attorney and not feel like they're really on the department's side as opposed to the parent's side.
Thank you, Cynthia. Cassandra, you had a question?
Yeah, I was wondering if there was any recommendation on what we should do if we're not being invited to those initial assessment meetings before the custody hearing. Because I know in my district we've asked before and it doesn't happen. And so it's very hard to go from the custody hearing, which is a lot more ducks to get in a row than to have met them at that meeting.
I'm learning that that is not a practice in every county and every district, and I haven't figured out quite why. But I do think that reaching out to the CCA and just telling them this is what I would like moving forward. Maybe it's reaching out to the CCA as soon as you get that notice of the hearings and saying, hey, when is the initial assessment planning conference scheduled? I would like to be invited. And then I also think if you're not getting responses, then reaching out to the regional managing attorneys to let them know, hey, I'm asking to be invited to these things. I know you guys don't always know who the PPW or the PPW supervisor is at that time, because all it has is the investigator information. But I do think those investigators are the ones scheduling that. And so asking them, hey, when is this meeting and can I attend, is going to be good too.
I think it's also helpful to reach out to the CCA. We don't typically go to those unless there's another attorney involved. So I would generally not even know or know very shortly before it happens when these assessment planning conferences are going to happen. So if you know you're going to try to go, to let the CCA know so that we can make sure that somebody's there as well.
Thanks. We're gonna move on. So again, part of Zealous advocacy is supporting dignity. And that, I mean, I think this is just, it speaks for itself. You want culturally and cognitively appropriate services, simple manners can help the client have a framework of honor. So referring to people by either by title or by, full name, not assuming that it's okay to call them mom or dad, but having that kind of respect and as it says, err on the side of formality, and that we all have that duty of scrupulous fairness. And even though we know that the CCA has that, but it's also all of us do in this process have that responsibility. we want to also be respectful for us as counsel, as respondents counsel, that we are not pressuring our clients either to take a plea or to go to trial. We need to be listening to what they have to say. We have to assess the case, use our professional judgment, but ultimately we have to remember that it's their decision about whether to enter a plea or to go or to take the case to trial. We also want to remember who else may be involved, that we need to collaborate with in that process, like the tribes or other family members that may need to be involved. Let's see. Cynthia, did you have more to add to that?
Sorry, I got a drink real quick. I just want to echo the duty of scrupulous fairness. While technically it is the children's court attorney, which means that we should not only be doing our job representing our clients, but making sure that the due process rights of the parents are honored as well. I think it is good if all of the parties consider that they have that, so that we are all working to make sure that the due process rights of the parents and that the best interests of the children are being accomplished. Because the more we work together and the more we help each other out, the better outcomes we're going to have for families. Because we all have a lot on our plate. We're all struggling sometimes to make sure everything gets done. And if we can really help each other to try to get to that end result, then I think it's better for the families.
Okay. Communication strategies. John, did you want to pick up on this one? And
Yeah, so
Catherine?
I just wanted to go back to the last slide, just a couple comments in regards to that, that a lot of us, most of my colleagues in family advocacy uses, when we initially meet with the client, we're hoping that that's not the same person that we see at the very end of the case. You know, especially with the trauma, with the substance abuse, with alcohol abuse, with trust issues. We're hoping that what help that they get through any counseling is going to change them, and they're going to be a little bit different. And that really helps me remain on calm enough, because some of the cases that come through can be disturbing for a lot of folks. So that's an important thing for me as well, in regards to just supporting their dignity. One of the ways that we try our very best to keep in contact with our clients is we use a lot of text messages. Clients seem to they're kind of like the kids today. They love their phones, and they're on those text messages all the time. We make text streams with our New Mexico Family Advocacy team that includes the parent mentor, includes the lawyer, the social worker, the client, so that we make sure that we're all on the same sheet of music. We set up meetings at parks. We go where our client feels most comfortable. Lots of times they don't want us to come to their house, and we're okay with that, especially if they're homeless and they don't have a place to stay. We'll meet them wherever they want to be met at, coffee shops, name it. We've probably done it. Catherine, anything to add to the communication strategies?
No, I mean, I ask parents a lot, like, hey, are you hungry? Do you want to go get some coffee? Do you want to go, like, wherever, to where they can feel comfortable, to where it's not, to where it feels more like a casual meeting. It's not this big stressful thing, right? It can feel more casual and more relaxed, and just where they can be able to develop a professional relationship with us, that they know we're there to help them. We're not there to tell them what they did wrong or what was bad, but just how can we help you alleviate that? Like, what got you to there, and what can we do to help support you and your family? Like, what supports do you think that you need, right? Because the department is always going to have their things that they need or want from a parent. But sometimes they may, like, the department may say they need a parenting class, and the parenting class they're going to is for babies. But maybe they need something that's for bigger children. And we'd be able to talk to them about that, and then say, well, hey, how about we call your PPW and ask about that? Like, in the beginning, we do a lot of calling with them. And then it gets to where they feel comfortable doing it themselves and learning that they can advocate for things with their social worker, with their attorney, with their PPW, and ask for different things.
Yeah.
But just a lot of communication and meeting them where they're at.
And the social
Yes,
workers
and-
will request releases of information so that we can talk to any providers that the client may be going to. I love talking to CYFD and the PPWs and the county office managers and any of the supervisors, because then I can kind of get an idea of what's going on from their end, and I'm not assuming. I think when we assume too much about one side or the other, that's when communication gets really, really messed up, and then the client is not understanding, and that's probably the worst part. We want that client on the same sheet of music with everybody else. Again, as Catherine said a little bit earlier, we advocate for the clients, and there's not a lot of times that we will tell CYFD everything. But you know, if we know what's going on, if through email, texts, meetings, the new IPMs, any of the mediations, it makes it so much easier for us to be able to calm our clients down, get them in a state of mind that, look, we're here to help you, to get you reunited, because ultimately that's the end goal. And I think if we all look at it that way, it makes it much easier for us to attain that goal.
So we do at CYFD, we also want to talk about those communication strategies that we talk about on here. So when John and Catherine are talking about including their whole team in a text group or an email group, we try to do that as well, including either Respondents Council or the FAP workers, along with the, CYFD is working on the QPI, the Quality Parenting Initiative. So including our resource parents, our relatives, along with the parents in those text message groups and emails, so that everybody knows what's going on all the time. Asking what's best in a text message. We have some clients who struggle with reading, but could see, recognize names, recognize phone numbers or dates, know days of the week. And so if we send, text messages that say therapy and a day and a time to everybody, then it's a reminder for that parent, and really being cognizant of, we're not sending long text messages to that parent. They're usually short messages. We talk about ongoing appointments, and we keep those same appointments. We have a weekly meeting we have to do on your treatment plan to talk about barriers in your case and what's going on. So let's do it every Monday at 4 o'clock so that we always know. And that works really good. If we need to invite our Respondents Council, there's times where Leslie or Sherry has had to be on those phone calls with clients and us, so that we're all on the same page. And then keeping in mind that if we have like Spanish speaking families, that we're really providing that information to them in Spanish. And we've learned to use Google Translate very well, and it works pretty good. And there's a couple of other things that we've used in the Sandoval office to talk with clients. And the text messages through Google Translate work really well, we've decided, or kind of figured out.
Thanks. So, yeah, I mean, essentially the bottom line is, how do you zealously advocate for somebody that you can't communicate with? And there can be all kinds of barriers to good communication. They can be structural, they can be financial, they can be language, they can be educational. And it really is incumbent on us as advocates to find out, to identify those barriers and find ways of communicating effectively with our clients across those barriers. And I think, Cynthia, did you want to talk about kind of the due process issues around that and what's required from the department and the court?
You're on mute.
You're on mute.
Sorry, one of the things we have to address is making sure we have proper interpreters. So the department typically will make sure that if an interpreter is needed, that we arrange for that for the custody hearing. But generally, it's the respondent's attorney that should be making that decision as to what their client needs. And so after the custody hearing, then it would be up to the respondent's side to make sure that there's the appropriate interpreters. I know sometimes the courts take over that and will flag cases, but not always. So yes, the department will typically do that for the custody hearing just because it happens so quickly, but after that, it would be up to respondents' counsel.
Thanks. This is just this next slide is just kind of an example of something that Kristen uses, you know, as a way of communicating. Again, you know, there may be few things like Cantrell was saying that the client recognizes, but they certainly recognize their name, they recognize a number. And maybe you need to add a face to that as well, so that they know who it is. Okay, so this about this is again cultivating those relationships, because in order to be you know, an effective advocate, sometimes you may need to enlist the assistance of others in putting out the fire, in addressing something, and the importance in all of those relationships. All of us do hard work. We're overworked. We have too many cases. The work that we do in and of itself is hard. And so just to kind of keep your ego in check, because it may be that support staff at the court or at the department, it might be the one person that's going to help you get whatever it is that you need to get done for your client tomorrow. And so it pays off to not be dismissive or short with them today in order to do that. Let's see. And Cynthia, did you want to talk any more about that?
Yes, I think we all recognize that we do a very difficult job, and there's a lot of emotions that go with this work. That it's easy to lose your cool, get angry with others, because it is such an emotional thing, because it is such an important piece. We're talking about people's lives and their families. I think one of the things that's helped me over the years is being able to understand that is what's happening to people, and try to accept that people aren't necessarily acting out because of, you know, they're just being mean or whatever, that maybe that there's other reasons, but that if we can act with kindness towards each other anytime we can, if we can take that second to take a deep breath and calm down and try to come from a place of believing that everybody's really trying to work hard and respond in kindness, then I think it helps us all with our own self-care. It helps us all to be able to continue to do this job and to be able to keep good workers, good respondent attorneys, good GALs, good parent mentors. It just helps the whole process so that we can keep the good people here so that they can handle it. That doesn't mean that when things go wrong and if things aren't done the way they're supposed to be done, that I'm not going to raise that in court, that we're not going to address that we're not going to push back, but I can do that in a way that's not being mean and acting like a jerk about it.
Exactly. And by the same token, as you know, as an advocate, whether it's as an attorney for the parents or attorney for youth or child, same thing. I mean, there may be things that should have been done that didn't get done, but what's the best way to approach that? Obviously, you're not going to let it go. If it was supposed to be done, you need to raise it, but it doesn't have to be in a way that alienates the person that was supposed to do it, because you still want them on board for the next thing that needs to get done. Or if it hasn't been done, it still needs to be done and you still want it to get done. And so it can work against your interest to just to be hard, to be difficult, to be rude, to, you know, be harsh with somebody. Better to figure out how to communicate clearly and say, this, I had this expectation, this needed to be done, it wasn't done. How do we move forward and get it done? Rather than staying focused on the past and blaming and being angry about it. This next slide is about, so this is other people that are in our orbit that communicate with the court. and maybe provide reports and also communicate with us, and just sort of how we deal with them and the information that they produce. And just remembering, it may be, there's kind of I know for sure for myself as a respondents counsel, I am concerned about what kind of communication happens with the CASA. Because I don't know what they are going to say to the judge about my client. I don't know what their perspective is going to be, and how that may get translated. And so we want to be careful in that communication. But we also, again, the flip side, we want to be careful not to cut off all communication, because again, these other people, these other players are going to communicate with the court and present information to the court about how the case is going. And that goes for, I think, Cynthia, you can talk about how that goes for department, or Cantrell, whichever one of you, for department staff as well, that what ends up in those reports that go to the judge can also not be particularly flattering to the department. And you guys have to deal with that too.
That is accurate. And so we do have those conversations with relatives and resource parents about information shared. And this is remembering this is a professional relationship. We do have those conversations with them, and especially youth. We've had to have that conversation with them when they get the report in court and they're like, I didn't mean that. Well, this is a professional. This is not a friend. So remembering that. And then for the Substitute Care Review Board as well, we've actually haven't really interviewed a lot of workers in some of their reviews lately, but being mindful that those reports go. We were kind of told for a long time that those were systematic kind of reviews to go over what the system was and not necessarily to review this specific case. And I think that's what they've been trying to get more back to. Just understanding what is going on in the system and how better to manage or support the system rather than individual cases and pointing out those wrongs that have been done in individual cases.
Cynthia, did you want to follow up, or?
No, I think everybody said it.
Okay. And then also as parents counsel, just always a reminder to our clients that anything they say to either the Substitute Care Review Board or to CASA is not confidential, and can absolutely be disclosed, which is why one of the great things about having a team as part of to advocate is that I know John and I, when we've had cases and the CASA wanted to talk with our client, John agreed to go be with the client for that meeting, so that the client could feel comfortable that somebody was there to make sure that, they didn't say anything that maybe wasn't the best thing for them to say, because it could get repeated. Let's see. Okay. Disclosure and discovery. Cynthia, you want to start out on this?
Sure. So we have different discovery rules than criminal and civil because we act on different timelines, and because our timelines are so quick, we've had to basically, our discovery rules are that you just give everything pretty much over to all the other sides, so we don't have to worry about fighting over everything. The state, from what I understand throughout the state, and I don't know if it's all areas, but I think it's most areas, are doing electronic files reviews now. And so either you're going to have the PPW's file scanned and then sent to you with whatever redactions need to happen, and that's attorney-client privilege or confidential informant information. Sometimes there might be social security numbers or things in there that might also be redacted. But for the most part, it's just the file that would be provided, or you would be given access to the hard file where you have time to go in and just review it and then mark what you need copies of. Make sure that if you have to go in and do a hard copy review, that you're setting enough time to review that. Some of these files are huge. The more children there are in the case, the longer the case has gone on, the bigger these files are going to be. And so you want to make sure you have plenty of time to review and find what you need. There's also, so it says ask for a working file and to see things on the computer, the facts, narrative documentation, and home visit documentation. So in addition to the permanency planning workers file, the hard file, I believe when they're talking about the working file, that would just be the stuff that hasn't been filed yet. So a lot of the PPWs, they can't, surprise, surprise, don't have the time to do their filing on a daily basis so that every time they get something in, they can go put it in the file. So just a reminder that they need to check the filed before it gets filed file. And then we have our fax system where we keep a lot of information electronically, and that's where we keep the narratives. So all the work that the permanency planning workers and investigators do on the case, all their notes go into that, home visit notes, also visits with the children. There might be parent-child visitation documentation. All those kinds of things are in the fax system. And so make sure you're telling your CCA, if you don't see that was provided, that to provide that, they may have just forgot, because they usually would just get the PPW file scanned or provide it to you. Let's see. And then to remember that actually all of the parties have this obligation. It's not just the department, that all the parties have an obligation to turn over information, and the rules are provided there that outline what you are and what you are required to provide. If you need additional discovery, then it is by court order only, and you have to have a good cause to request that. Again, because theoretically we should be providing everything, all the parties should be providing anything necessary to proceed with a trial on a short notice already. Additional things would be out of the ordinary, and the court would need to be able to review that and decide if it's appropriate.
Thanks. So it is a challenge because our timelines are so short in these cases. And what I would say is, I think sometimes it's because it is a lot sometimes to, and we know as GALs or respondents counsel, youth attorneys, we get the notice of disclosure, right? That we can come and review the file, and it's sort of a standard thing. But you really need to follow up on that. I guess what I would say is, sometimes we know that our cases vary a lot. And there are some cases where your client is very clear from early on that they are not interested in fighting about this. They want to enter a plea. They've acknowledged, whatever it is that they feel that, the mistakes that they've made, they're ready to move forward. They just want to move on. And then we also have the other clients that are absolutely, digging their heels. They want to go to trial, no matter what. And no matter if you're advising them that maybe the case isn't such a strong case or good case for trial, but there may be other reasons that they need to go to trial. They have emotional reasons that they need to go to trial. And again, this is where I find having the NMFAP team, the social worker and parent mentor on board to help kind of work through that, to be incredibly helpful. That there may be other reasons other than that the facts are in your favor to go to trial for the benefit of the client. But if you have one of those cases, or if you are not sure yet, really clear about the strength of the department's case or your case, I guess I would just say, how can you really be a zealous advocate without having reviewed the file? It really is critical to zealous advocacy to take a look at that file if it is a question about whether are you going to go forward with trial, or if you know already that you are going to go forward and take an adjudication to trial. And then later in the case, as the case goes on, you really should be and need to be getting the provider reports, visit reports, all of that as time goes on. But we all know that often doesn't happen. I will often just send an email saying, I haven't gotten any reports on this case for a while. Can you please just send me all the provider reports? Because if you do wait until, well, first of all, it makes it pretty hard for you to assess whether you're going to have a good case if your client wants to contest a change of plan or a TPR. If you don't have those firsthand reports, but also it's gonna then you're gonna just have a massive amount of material to sift through in order to make that decision, and better if you're getting that as you go along. It's true that in terms of getting court order, additional discovery that's not agreed to, you are going to need a court order. But I have definitely had cases where when we were contesting a termination that we were able to have witness interviews. They were not depositions. It was not, sworn, but we were able to have witness interviews, and it never hurts to ask, to interview the department's witnesses. Thanks, Louise. Okay, communications with represented individuals. So again, you want to start out on this? Yeah.
Actually, I'm just going to interrupt a little bit here. Go ahead, John. Sorry.
No, we both saw the time ticking here, so just wanted to give attention to the 1 o'clock time frame. Okay.
Thanks. Okay, so communication with represented individuals. Cynthia, you want to start out?
Sure, I can. Just remember that everybody has different roles that you're working with, and they all have their own different rules, where the guardian ad litem may be acting in the best interests and can take information in and provide a lot more information that would be different between the youth attorney or the respondent's attorney. Also remember that the PPW is a represented party as well. So don't ask the caseworker anything outside of the presence of the CCA except for basic case management information. And that's things like, what's the address of the therapy office? What's the phone number for my client to call in? What time is that visitation scheduled for? Anything beyond those kinds of questions, you need to make sure there's a CCA. You can email, and if you email, just make sure you're including the CCA on that email as well. Get permission from the other counsel in the case before you have any unsupervised contact with the client, whether they're an adult or a child, and then consider whether or not you need a signed waiver.
And I'm going to say that, this is really important to make those distinctions. What is it that you're asking information about? Because if you're talking about legal issues in the case, is there going to be a change of plan? Things like that, that absolutely that needs to be discussed with the CCA, not with the permanency planning worker. So you really need to be careful about that. The flip side is true too, though. I will say that as a respondent's attorney, I have been very concerned at times when department frontline people have talked with my client about legal issues, about are they, about the department's proposed change of plan and kind of what do they want to do about it. I want to be there for those discussions. Those are discussions that need to happen in the presence of counsel for both sides. And so you just need to be really careful about that as well. I'm going to just tell you straight out, I'm one of those that thinks that that GALs, yes, they have a different role, and it's as advocating for best interest and all of that. But I will tell you that when I'm a GAL and I want to visit my client, and the client is on a trial home visit or is in the respondent's home, I always clear it first with the respondent's attorney. I tell them, I'm scheduling this. I need to go visit my client in your client's home. Here's a heads up. I'm real clear that I'm not going to be talking to their client about anything other than the child and how the child is doing. And if they want to be present, or if they want to counsel their client before I'm there or whatever, that's fine. I have to be able to visit the child in the home, but I still need to be very clear about not having communication with that parent, inappropriate communication about them, about their compliance with the case plan, about anything like that. So we just want to really be careful about those. Okay, conflicts, personality conflicts, something that can really get in the way. When somebody pushes your buttons, what does that do, and how does that affect your representation? Let's see. I think Cantrell, you want to start talking about this, and then when I hear from John and Catherine also.
Yeah, I think that if you are struggling with a worker, with a CCA, or someone in the department, it really is a good idea to just go up their chain. It also is to talk about those conflicts, right? I don't have any more power in this situation than the worker does in this arena. My CCA doesn't have any more power than the Respondents Council, and just remembering that. However, we have children in custody, and so to parents, that looks like power. That is power. And so just being mindful of that. I had a parent tell me one time she really felt like we always had this threat over her head about keeping her kids in custody and they wouldn't be returned. And I had never really thought about the words that I was using, that's what it made her feel like. So just remembering it and naming it and being cognizant of it. This is my client, but it's also Leslie's client, and being mindful that we're both there to support them. We're both there, right? It's also John's client. It's also Catherine's client, and we're all there for one reason, to help keep families together. I'm talking about those negotiations and those mediating things within our case. We really want to do that with our Respondents Council, with our clients, with our GALs, right? I can't just say yes to everything Sherry wants as a GAL in a case. I can't say yes to everything Leslie wants, but could we negotiate? Could we talk about it? Could we mediate some of those things in these meetings that we have? And I do think that utilizing supervisors is good. We have a lot of new workers. And so have they had that experience in doing a lot of this kind of communication and working around things and being mindful of people's feelings? No, because I can tell you when I was a baby PPW, I didn't know that. And it took experience to learn those things and for people to point them out. And so telling my supervisor helped me. And so going up that really does help.
Thanks.
Go ahead, John.
So from my perspective, I grew up in a military culture, so chain of command was very, very important. When it comes to personality conflicts, I think Cantrell hit the nail on the head. We're all here for one purpose. That purpose is to hopefully reunite a family. And again, I'll say that we all have our own roles, and sometimes we're going to bump heads. As long as we keep the perspective of what that goal is, I think things are going to be much better. It makes it easier when people all get along. Don't get me wrong. But that's not the perfect world that we live in. So being able to talk, being able to bring those things out it doesn't have to be around the client one-on-one. If it's NMFAP with CYFD or lawyer to lawyer, whatever it may be, I think it is important that we do talk as adults. And because again, we're trying to be role models for our clients. And if those personality conflicts come out in meetings, they're going to pick up on it very, very quickly, and they're going to think that they can do it as well.
Thanks, John. Okay. So again, just in terms of maintaining those relationships and being able to sort of step back, put your ego on the back burner, still be a zealous advocate, but maybe you ask questions instead of making statements. That might be the better way to advocate for your client. Sort of acknowledging the strengths of the others in the room, the supports of others in the room, and not being afraid to say, well, not only don't be afraid to use your power for good, but also don't be afraid to say you don't know. There's something that you don't know about this, whether it's a tribal custom or a family culture or whatever it is that you don't know and are willing to learn from the others at the table, can be a huge benefit to your client, rather than assuming that you know it all and then missing something important, missing something that you really should have picked up on for your client, missing a need that your client has because you've wanted to be the whatever, the know-it-all in the room, the star in the room, but being willing to kind of step back, and because we do have power. Those of us that are doing this, whether you're an attorney or whether you're working for the department, or part of the attorney's team, we do have, and especially in relation to our clients, and we need to be able to moderate that power and use it for best purposes. Was there anybody else, any of you, Cynthia, Cantrell, wanted to add to that? Oh, okay. Two heads are better than one. I think we had actually maybe John, but John, are you still on here, or do you need to leave? I think we had you and Cantrell on this one.
I can give a few comments and then I'm going to head out. I'll just go back to what I've been echoing the entire training here is team concept, one goal. As long as we understand that everybody plays different roles in this, and we're cognizant of that, and we can show respect towards everybody. I think that shows our clients that, hey, that's the way to kind of do it. Because again, the end goal is to hopefully reunite these families. And I know it doesn't happen every time, but as long as we're there to best support our client in each role that we play, as long as we're able to listen to each other, because, good old John may have something pretty good to say. Catherine might have something pretty good to say. CYFD may have something good that could help us, that we could intervene with our clients. I mean, as long as we're sitting there and listening, two heads always better than one.
Thanks.
So I do think that this, we learn a lot from counsel. We learn a lot about what we're going to do in different cases. I gave the example, I think for this slide, to the team about, I didn't know what a directive verdict was, and I had never heard of that. And that responding counsel did that. And I was like, I wish I had understood what this was beforehand. I'll be more cognizant and more aware next time. But I learned from those things. I learned from hearing Leslie talk about other cases in other jurisdictions. I hear about Catherine and some of the things that some of her clients have gone through, some of the challenges and barriers, and it makes me think later on, I wonder if I should have asked that question to another client. So I think it's us asking. It might not be specific about cases, right? I'm not going to be asking the judge about specific things on a case, but there might be things that we're in work groups or other things that people say, this happened in another case, not giving names, not giving other things, but it really helps. When we talk about using the social work concept of supervision, right, we talk about things and hear what other ideas people had. I really do think that's good. We've talked a lot in these ECHO meetings about visit hosting, about icebreakers, about other things that can happen in cases that happen in certain jurisdictions. And I really wish that some people would take those back to their jurisdictions and use them, right? Why aren't more GALs or responding counsel or judges asking the department, can I have a visit host on this case? Can we utilize this? We've heard that that's not happening, but I'm only getting better as a social worker if my respondents counsel makes me better.
Thanks. Okay, I'm looking at the time, so we're going to kind of whip through this. So when all else fails, for counsel, sometimes you just have to file the motion. You try to work it out, but sometimes there just isn't, you're just not going to meet in the middle. And especially if it is something that is particularly important to your client, whether that's the parent or the child, the youth, then you just need to file the motion. You need to remember that that when you file that motion, you need to seek concurrence of counsel. There are only a few motions where it's because it's obvious that it's going to be opposed that you don't need to do that. So like a motion to dismiss, motion for new trial, judgment notwithstanding the verdict, summary judgment, an ex parte order, if you're asking for an ex parte order about something, relief from a final judgment. So those kinds of motions where it's presumed that they're going to be opposed and you don't need to seek the position of other counsel. But generally speaking, if you are in a place where you've not been able to reach agreement and you just simply need to file the motion, and being a zealous advocate means making that commitment to file that motion. Don't wait until the next hearing and then bring it up, because then there's not going to have been time for you to prepare your arguments, for the court to be prepared to hear your arguments about it. It's really important that as zealous advocates, we go ahead and file those motions, get the issue in front of the court when we have not been able to reach agreement. Cynthia, did you have anything you wanted to add to that?
I think just as a reminder, like we've been talking all the way through this, that's part of the job. And I think Cantrell said it really well. The only way that we get held to a higher level is because respondents' attorneys and GALs and youth attorneys push us to do better in court as well. So when you're not getting what you need, things aren't happening with the PPW, the CCA is not doing what they're supposed to be doing, filing those motions, bringing those issues in front of the court, that should never be a bad thing to do. That should be how we work problems out. So yes, please do those.
And being respectful of everybody's time, I just wanted to take this opportunity to thank everybody for coming. I know that Leslie or Cantrell and Cynthia, John, you guys Catherine, you may have some other things to add, but I just wanted to remind everybody if they can please fill out the survey. Jen had posted it in the chat. As I stated at the beginning, it's very important for our data. And then just to remind everybody that on June 13th, it's actually going to be the final ECHO session. And the topic will be preparing your client to testify using a team approach. So I just wanted those two reminders as we're nearing the end here. Thank you.
Thank you. And I'm sure we'll try to hang on for a few minutes here. We just have a couple. This is the last slide of our presentation. And that is that you just a reminder that you can't be a zealous advocate if you're burned out, if you are unable to do the work, because we all experience it's hard work. There is secondary trauma is real, compassion fatigue is real, burnout is real, and the importance of taking care of yourself and supporting each other. Being trauma responsive isn't just being trauma responsive to your clients, but it's being trauma responsive to your coworkers as well, so that we can all get through this and continue to do the work that needs to be done. Cantrell, Cynthia, Catherine, did you want to add anything else?
I think you said it all.
Thank you. Okay. And then last, just a reminder, these were Kristen's curriculum and slides. We really appreciate her. Our email addresses are on this. And I can hang out for a little bit. I don't know, Cynthia, Cantrell, Catherine, if we want to look through and see. I think there might have been a couple of questions in the chat, and if anybody else has questions.
I think we got all the questions in the chat. So if you had one that we missed, please let us know.
I think there, let me see. Might have been one. Oh, okay. So Jim had something. The discussion about initial assessment meetings, but to be comprehensive, how do those even make sense without a representative for the child? The child's not even present and probably shouldn't be without someone to speak for the child. So this is a meeting between the department and the respondents only? Well, no, actually, Cantrell, you want to talk about how the initial assessment planning conferences usually go and who's invited? At least in Sandoval County.
I know, sorry. I say responding counsel, and because there's only 4 of them for us, and one of them is always a GAL, so I just say that, and I mean everybody. But we do invite them, and we talk about what's going to happen in the hearing. We talk and ask, should kids be invited to the initial to the custody hearing. We have that conversation with the GAL or youth attorney at that time. We talk about what the icebreaker looks like. We usually talk about visits at that time and what they're set ups for, so that we don't have to have that conversation in court the next day. And then we go through the initial assessment plans. I appreciate having counsel there, and it helps my custody hearings go faster. And I wish that I could have more. I wish I could invite people sooner in cases. That's the earliest.
Thanks. Were there anyone else that have any questions?
And my response to Cantrell is, are you training other county office managers? Please tell me you are, because they don't see that. They don't see that having everybody at the APTEC makes the custody hearing go better. It's really frustrating, but thank you.
I try.
Okay, well, thank you very much. We really appreciate you being here with us, and make sure that you please fill out the survey. And any of us are, willing. That's why our email addresses are there if you want to reach out and have any questions for any of us. John?
Yes, thank you. And again, the reminder for the next ECHO session will be June 13th. Thank you, everybody, for attending. And good job, Cynthia and Cantrell, Leslie, Catherine, and John, wherever you went. Thank you.
He had a meeting. Thank you.